William Wallace stood before the court of King Edward I in 1305. The court was a legal institution, not a theater, yet the trial turned into a spectacle of state-sanctioned dehumanization. Spectators saw a rebel as a killable object, not a citizen. The execution was advertised like a hunting season announcement. Crowds gathered, eager for blood as they would for a drama. A modern parallel appears absurd. A quarterly earnings call that turns investors into prey. The risk shift was clear. A legal decree turned the rebel into a spectacle. The public execution demonstrated how societies rationalize hunting humans like deer. The smell of burning flesh mixed with the scent of fresh pine. The sound of a falling axe echoed louder than a stag's roar. The audience could smell the irony before the fire. The court of King Edward I recorded the event in official rolls. No Magna Carta clause protected Wallace from this fate. The legal framework of the Assize of Clarendon allowed such displays. The audience's reaction reveals a social psychology of public executions. Rationalization demanded myth. Myth demanded spectacle. How did society rationalize hunting humans like deer? 11th century, England functioned on webs of mutual obligation. Forget romantic notions of chivalry. Survival demanded economic pragmatism. The Liege's Henrici Primi, compiled around 1115, codified this brutal arithmetic. Murder wasn't inherently wrong. It was merely expensive. Wurgled prices assigned precise values to human life. A seorl cost 200 shillings. A then demanded 6 times that. Payment prevented blood feuds. Kinship groups acted as collective insurers. Failure to pay meant collective liability. Imagine your cousin defaults. Suddenly, you're liable. The Royal Society would weep at the actuarial mess. This system relied entirely on social pressure and local enforcement. Tithing groups policed members. 100 courts mediated disputes. It was fragile. One missed payment unraveled the whole tedious tapestry of mutual distrust. Economic bonds restrained violence. But what bureaucratic innovation would shatter these ancient restraints? 1166, England. Assize of Clarendon introduced. Bureaucratic efficiency in justice administration. Formal outlawry born. State-sanctioned transformation of citizens into prey. Eustace the monk witnessed this. Liege's Henrici Primi influenced it. Normandy's feudal system was a model. Grágás from Iceland also played a role. Hunting license for outlaws. How far would this English export spread across medieval Europe? Medieval Europe waited. Justice administration changed forever. England's innovation would not stay contained. England's innovation traveled swiftly to 12th century Iceland, that Scandinavian icebox. The Grágás legal code institutionalized outlawry here. But Iceland's brutal scarcity economics warped the practice. In this frozen clan society, a man's head became currency. His value equaled winter provisions for a family. Starvation sharpens moral flexibility, doesn't it? The Grágás marketplace normalized bounty hunting as legitimate trade. Outlaw skulls funded farmsteads. This wasn't justice, it was protein-arbitrage. Could this system withstand the greed it unleashed? Consider Normandy. 1215 wasn't just Magna Carta year, it was peak pirate season. Eustace the monk traded prayers for piracy. His channel fleet levied taxes kings couldn't collect. Think of it as aggressive maritime consulting. The Magna Carta demanded expulsion of mercenaries like him. Clause 50. They tried. He flourished. Normandy became his operational hub. This wasn't Iceland's skull market protein trade. This was systemic extortion. Ships paid or sank. States lost revenue streams. The Holy Roman Empire watched. England fumed. France shrugged. Piracy became the region's dominant economic model. Efficient, brutal, taxation without administration. What happened when the prey organized against hunters? Consider Scotland, 14th century. The Crown's harsh outlawry laws intended to isolate rebels. Instead, they forged them into coordinated units. William Wallace didn't operate alone. He commanded a disciplined force. They exploited terrain. They struck supply lines. The Scottish courts under English occupation proved useless against this. Their own legal framework created the monster. Outlawry wasn't containment, it was recruitment. These weren't scattered criminals, they were proto-armies. Permanent lawless zones emerged. Borders meant nothing. Enforcement evaporated. The Holy Roman Empire noted the contagion. Resistance became structural. Authority eroded from within its own design. The prey became hunters with strategy. How would institutions respond to their creation turning against them? Consider 15th century England. Robin Hood ballads circulated widely. They weren't mere entertainment. These were coded critiques of institutional failure. The ecclesiastical courts detested them. Why? Ballads glorified resisting unjust law. Outlaws became folk heroes. This inverted the moral order. Authority was mocked. Public sympathy shifted decisively. The crown saw the danger. Censorship attempts began around 1450. They failed utterly. The narrative spread faster. Each ballad was social commentary disguised as song. It revealed the hypocrisy. The law created its own enemies, then celebrated them. Folk memory recorded the rot. Could the law survive its own dehumanizing logic? The crown's censorship failure echoed through taverns. Ballads amplified dissent. By the 15th century, the Holy Roman Empire faced collapse. Outlawry proved catastrophically counterproductive. Public executions fueled martyrdom cults. The Reichsrat pivoted sharply. This imperial council centralized judicial power circa 1470. Outlawry was formally abandoned. It had manufactured too many folk heroes. Incarceration replaced dehumanization. State-controlled prisons emerged as containment tools. This was no moral evolution. It was damage control. Administrative pragmatism triumphed over symbolic terror. The empire traded spectacle for cells. Yet control remained illusory. Corruption seeped into prison administration. Rehabilitation was never the goal. Containment bred its own pathologies. What permanent scars would this experiment leave? Consider Magna Carta, 1215, heralded as liberty's dawn. Yet English common law courts preserved outlawry. This medieval relic declared a person homo sacer, outside all protection, a walking corpse legally. Magna Carta promised due process, but outlawry remained. Its shadow fell long. Even Robin Hood embodies the contradiction, celebrated hero, yet technically outlawed. The Assize of Clarendon formalized this exile, a brutal tool for state control. It persisted centuries past its supposed obsolescence, a ghost haunting jurisprudence. Its dehumanizing logic echoes. Modern crises whisper its principles. How will history judge this medieval innovation? 14th century England sharpened outlawry's blade. William Wallace faced it in 1305. The crown declared him Caput Gerat Lupinum, a wolf's head, killable on sight. His humanity legally voided. The Vatican occasionally protested such extremes, yet the mechanism persisted. Dehumanization as judicial tool. This corrosion of justice echoes. Expediency over ethics remains law's siren song. The crown's convenience trumped Wallace's dignity, a blueprint for systemic failure. Legal historiography reveals this rot. Our institutions still flirt with voiding personhood. The trap remains set.